This is case number 113267, Luke Gannon et al. v. State of Kansas et al. At this time, I would ask counsel to please rise and state their appearances.
Here for the State of Kansas, Your Honor, Stephen McAllister and Arthur Chalmers.
And for the appellees, Alan Root and John Robb.
Very well, thank you. For the benefit of our audience primarily, those who are here physically and those who are watching this being streamed live over the internet, I wanted to take a moment to recite an excerpt from our order of July 24th of this year. The appellants are granted a total of 60 minutes for oral argument and will argue first, deciding among themselves how to split their time. Appellants may choose to reserve a portion of time not to exceed 15 minutes for rebuttal. The appellees are granted 60 minutes for oral argument and will argue after appellants conclude their main argument. What is not in the order is my announcement, and that is it is the court's intention to take a break after the main argument made by the appellants. I also want to make another announcement, and that is to indicate we have two justices who are recused from this case, Justice Carol Beyer, Justice Caleb Stegall. They are being replaced as justices today by the following judges. To my immediate left, sitting in for Justice Carol Beyer, this is the Honorable David Stutzman. He is a district judge from Manhattan, and you court watchers may remember that he also sat on this case, Gannon 1, about 2 years ago. To his far left is the Honorable Mike Malone, who is a longtime district judge, now retired from Douglas County, who had sat in Lawrence. Judge Malone is a senior judge sitting exclusively by assignment for the Supreme Court. They will be participating in oral arguments today. They have read the briefs. They are ready, and they will also be participating in our case conference, which will start after oral arguments this afternoon, and they will be on this case until the matter is finally resolved. So, Judges Stutzman and Malone, I want to thank you on behalf of my colleagues for helping out the Supreme Court today. Does counsel have any preliminary matters? All right.
From the appellee. No, Your Honor.
Then you may proceed.
Good morning, my name is Arthur Chalmers. Your Honor, we would like to reserve 5 minutes for rebuttal if we may. The plan is that I will address topics concerning substantial compliance with the court's orders in Gannon, and then Mr. McAllister will address remedy issues pertaining to the order of the panel. And I hope to conclude my remarks in about 40 minutes, leaving Mr. McAllister about 15 minutes to address the remedy questions before rebuttal time.
5 minutes of rebuttal is granted.
Thank you, Your Honor. If it may it please the court. The court sent back to the panel as it pertains to this accelerated portion of the appeal, equity concerns under Article 6. And as recently as the July order that Justice Nuts just referenced, the court says whether the state has cured the inequities initially found by the panel and affirmed by this court in Gannon was the mission. In other words, the panel was to look at what was found to be unconstitutional in Gannon in those specifics, and then to see whether they had been cured by the legislature. The court directed that any cure that the legislature chooses shall be measured by determining whether it sufficiently reduces the unreasonable wealth-based disparity so that the disparity becomes constitutionally acceptable, and not whether the cure necessarily restores funding to prior levels. That's what the court said in Gannon. Now the test to be applied, so I have a bit of a cold here, the test to be applied is whether there is reasonably similar access to similar or substantially similar educational opportunity through similar tax effort. That's a legal test. If it wasn't a legal test and a legal question, then the remedy that the panel had ordered that you reviewed in Gannon would have simply been enforced, and we wouldn't be here this morning. The Neely case that was relied on in great measure in Gannon is the Supreme Court decision out of Texas, as you recall. And in the Neely case, the court looked at issues almost identical to ours as it relates to equity concerns, and granted great deference to the legislative determinations on these matters. Now, we are before the court on whether we have cured the remedy, whether we have complied with the court's orders, whether we're in substantial compliance. I understand that. And this court has said that the burden of proof is on the state to show that it has shown substantial compliance. We do not believe, however, that means that the court should not still grant deference to the state in these matters. In fact,
well, let's start with what evidence did the legislature use to decide that what it was doing would cure the inequities that were identified in Gannon?
Well, first, I don't know that that really allows itself to an evidentiary sort of analysis. I think that's a policy decision. But what the legislature did is had before it the analysis of the Kansas Department of Education that said that if you fully fund the old formulas for capital outlay and LOB aid, that it will cost approximately $138 million. And the mission then of the legislature initially was to come up with that funding, and it did. Thereafter, circumstances changed. It became evident that for reasons unrelated to equity, that it was necessary to distribute more funds, and the legislature took a look at the old formulas and changed them. But in terms of
But
evidence,
what information did the legislature use to decide that those actions would cure the inequities that had been found?
I think that the evidence would be compliance as nearly as possible with what this court has said were the full funding having been a successful cure of the court's order.
Well, but that was under a different formula, and the legislature chose not to use that formula to fund, even though you represented to the district court that the legislature would fully fund that formula. And I'm not trying to get into the you broke your promise thing. I'm trying to say that a decision was made after you made that representation to the tribunal as to what the state would do. The tribunal acted on it, and then someone changed their mind. And so what was the evidence that's in the record as to what the legislature looked at to make that decision? Because here's my problem. I think we made awfully clear in Gannon that this exercise is not just about putting more money into the funding of schools. It's not just about that. And so you've asked us to give deference to the legislature, and I'm trying to say, okay, if I give you deference, what did you use to make the decision that you made?
Okay. First, at the time the decision was made, would have been after tax levies had already been, taxes had already been levied. So the legislature at that point knew what the tax levies would be based on.
You mean in 2015? This is after the May 2014.
The levies had been made as it related to 2015. Mm-hmm. So they knew and could tell that, yes, we had the reductions of levies as it relates to the LOB, the narrowing of the levy disparity. Second, they knew what the LOB usage would be, and they knew what the capital outlay usage would be as well. And they had also information at that point about the average value per pupil, the AVPP, and would be able to look at that information and say, has the distribution of that changed? In other words, those things under the old formula the artificial spiking of the median and the 81st point or 81.2 percentile AVPP are those equity concerns. So they had as the baseline, we will fully fund, and this is how much money it will take, and this is what the Department of Ed tells us we need to raise, which they promptly did. They have then information as to why, under the old formulas, there would be an artificial increase in what they would be obligated to pay.
What was the artificial increase?
Well,
You've made a couple of arguments in your brief. One, you said there was your word was a precipitous increase in the assessed valuation per pupil, and an opportunistic, your word, use of or manipulation of mill levies by school districts. Was there anything else besides those two things?
Actually, I think it was Dale Dennis's word as far as the...
No, it was your word. I went back and looked at the transcript. He said significant, you said precipitous.
No, I will modify it.
And then precipitous ended up in the brief.
I think that those are the two changes, yes. There is the increase in the 81st.2 percentile and median AVPP.
Okay, so let's look at those two. Let's look at those two things then.
Well,
the first one is the assessed valuation per pupil. And what I thought was interesting was when I looked at the transcript of the 2014 hearing, Dale Dennis's testimony was to increase. He already had that increased number in his testimony. What you didn't say was that increased number was going to result in a higher appropriation being needed than what the 2014 legislature had already approved. But that 116,000 assessed valuation was mentioned twice in the transcript. So you guys knew that going into the hearing, in which you then represented that you would true up the amount at the next session. So you guys know that number going into the 2014 hearing, isn't that right?
I don't think that is right.
Well, he gives you that number it's in there in two places. So I can tell you that he gives that number. Maybe no one appreciated what was going on, but he did give you the number.
I would have to look back at the context of what he stated, but it certainly wasn't appreciated at the time that we were at that hearing.
And then what's the opportunistic use of mill levy manipulation or whatever it was you're complaining about?
There's a third factor I suppose I ought to talk about. When we have the increase in the AVPP at the 81st.2 level, that is a function of, as perhaps a subset, I don't want to forget that to mislead the court, that you have a spike in oil prices that are kind of unique to a particular district.
But that's what affected the AVPP.
Yeah, and you also have a reduction of kids, which in a smaller district you have fewer kids, that pumps up the AVP as well. But your question on opportunistic, maybe the word choice is indelicate, but it is.
It's argumentative. But that's fine. I just want to know what it is.
But what it is that when you have the opportunity to take and reduce your mill levies as it concerns the LOB and give tax relief to your constituents, the decision is made to, well, let's go ahead and increase the capital outlay instead, I suppose under the theory that it's easier later to, even though you increase that, to reduce it than it is to try to increase it. And that, in that sense, is what we thought and saw it as being opportunistic. Now,
there's nothing outside, but when the school districts did that, they had the authority to do that under that legislation. They didn't exceed their authority.
They did not exceed their authority, and nor are we critical that they did it.
Was it opportunistic when the wealthy school districts took advantage of the increase in the LOB cap from 31 to 33%?
I suppose you could phrase it that way. It was opportunistic, however, in terms of it was available to everyone as well.
Go ahead.
Can I take you back to the increase in the AVPP? You appear to be arguing that that was somewhat of a surprise, the 7,000 or whatever it increased, but I see that in fiscal year 2011, the 81.2 percentile increased 4896. The next year, 6,067. Looks like a trend there, and so I'm a little curious as to why this should have been such a big surprise.
Yeah, I thank you for the question, because I don't know whether it was a surprise or not. That's not our point. We're not contending it was a surprise. What we're saying is that the increase in the 81st percentile into this last year was not relevant to any sort of equity concern. And let me illustrate that in this way. We're talking about now a distribution among different districts on how money is to be spread. We're not talking about whether a particular data point along the line goes up or down. By what, you know, and the Intertech tells me that when a child is first born, the average length is 20 inches. So if you have 3 kids and they each have 20 inches long, then the distribution is exactly flat. You could say it's equal. The median is 20 inches. The 81st percentile is 20 inches. A year later, when they've grown an additional 10 inches, which I think is the average, now everything's at 30. It's completely flat, even though the median point has gone up. The key, I think, and the key I think that the legislature could rely on, and has evidence that coming up with an additional $140 million in equity aid substantially complies with this order, is that the distribution didn't change. On page 21 of our brief, there is a chart that shows that how, as you look along the distribution, it remains the same. Now there's a curve at the end, kind of tails up. Those are the districts that are not cash wealthy, but property wealthy. That curve exists and existed in the same fashion before. So if you have a spike that goes up at the particular median in a particular data point, that does not tell us anything about what we need in terms of the same sort of aid to assure that you have the sort of reasonable, similar treatment that the court has required under its text.
Except, Mr. Chalmers, I understand that you've admitted that you had the burden and at this remedy stage, and that you've admitted that, well, let me back up, but to make clear that in Gannon, we talked about a need to look at both structure and implementation. We focused in Gannon on implementation because the state had a structure in place that they had not fully implemented. But the state, in the remedy phase, the legislature chose to change the structure. As I read your brief, you're saying that this structure on LOB went from 8.12 to, I think the numbers you were, that they correlate to 77.71 to 81.1. So we have a drop in structure of equity, don't we?
We have a drop in if you look at it by way of an average, and it's hard to do because they do it in quintiles, as you know. So to average it out, that was the number that we put in the brief to illustrate that the number that the panel came up with, we don't know the math for it. We can't recreate it. But in terms of yes, is there under that sort of percentage analysis, now we're looking at what would be the equivalent in last year's AVPP, what the median level is. There is a drop. But that doesn't say anything. Again, that talks about that data point. It doesn't say anything about how the aid is distributed across all the districts. And that's the more important point. Intuitively, and I don't dispute, that if what we are comparing is the lowest Fort Leavenworth to the highest, which I don't remember if it was Burlington, I don't think it was Burlington, but we use Burlington as an example, that if you have any reduction in aid to a particular district, and compared to those districts who don't have aid, there is a reduction or a disequilibrium, I guess, if you want to call it that. I don't quarrel with that.
Isn't that all we need to know, though, then to answer that the state did not remedy the disequity? It made it worse?
That's what the panel felt. I think the panel's reasoning was that if you have any reduction off of full funding of the old
I'm not talking
formulas-
full funding. I want to set aside implementation or the amount of dollars that go into this. To me, that's a comparison that's very difficult to make when we have the fluctuating mill levies the AVPs that you've talked about and mill levy changes and things. So I want to look at the structure.
If we look at the structure, I don't know that you can really draw the conclusion without looking at the data, how it's impacted. Maybe on the outlay you could. On the LOB, I'm not so certain. In this year, when we're under a block grant, or the next year under the block grant, depending on how those data points under the old formula moved up and down, you could have a difference. But you have to talk about the data, not the structure. If you talk about the structure instead, what you have as it relates to the LOB is now a system of quintiles that affords more money, I suppose you could look at it that way, by way of aid to those districts that have lower property values. If you look at it by way of the outlay, what you have is, instead of having this arbitrary mark of the median that may or may not go up depending on, not saying anything about distribution because it could cut either way, I suppose. You have the starting point not at the median, but now the starting point is at the district that has the lowest cash value and works up. So structurally wise, it seems to be a fairer and more equitable system than it was before. The quarrel I think we have is only that it generates less money, and that in this last year, and maybe in this year, and that has to do with, I think, as you put it, the implementation, not the structure, as I would understand it.
But doesn't it mean less money? Doesn't that less money hit the poorest districts hardest?
Well, that's the nature of the test. Is it reasonably similar access to substantially similar educational opportunity through similar tax effort? If the test is a bright line, which is what the panel applied, if you say $1 less, I mean, we did increase it, $140 million. And we're saying, well, if you didn't increase it even a little bit more than that, that dollar less impacts those districts. If you compare those who receive aid against those who don't receive aid, it impacts those districts who do not receive aid disproportionately. It's the theory. But it doesn't answer the question, does it create under the test, something other than a reasonably similar access to similar educational opportunity?
Counsel, I'd like for you to back up. I think that's the third or fourth time you've recited what you purport to be our test, and I don't think that's our test, at least as I read our language in Gannon. Could you read the first 3 or 4 words again, please?
I've got, quote, reasonably similar access to substantially similar educational opportunity through similar tax effort.
I thought it was reasonably similar access. I wonder if your co-counsel could look that up in Gannon while you're up here, and then we can get that sorted out.
Well, Gannon is right here.
Well, while you're looking at that, this information about the structure and the distribution, you didn't put on any evidence that that was somehow going to cure the inequities that were found in Gannon, did you?
Well, we put on evidence as to what the mill levies were and how those changed. We put on evidence as to how much more money was available through the work the legislature did, the additional $140 million. So I think we did put on evidence.
Well, but that's all you put on, and that was through some spreadsheets. But as near as I can tell, no one went before, it's not in the record at least, no one went before the legislature, no one went before the district court and said, if you put $134 million into the deal, that this is going to cure the inequities that were found in Gannon. I mean, why not 100? Why not 50? I just can't find anything in the record or anything that the legislature looked at that showed that they were trying to meet the test that Gannon sets out, however it's worded.
I think that what the legislature did, Your Honor, is took what the court said in Gannon, which is that if you fully fund, you will have cured the inequities. And then it was against that standard we looked to see when they didn't fully fund under the old formula, more accurately, when they modified the formula, did they cure the inequities?
And what shows us that they cured the inequities by doing what they did, other than the fact that you put in more money?
Well, I
It
think
seems to be that's really all you're saying. We put in more money, now show us
No,
that
that-
it wasn't reasonable.
if I'm saying that, I'm not articulating what I mean, because the distribution among the districts didn't change. The levies went down.
But it did, excuse me, but it did change. You structurally changed. You imposed the quintiles, and then you changed the way that the outlay, the legislature did. And so you do keep coming back to saying, we put in more money, 140 million more money. But really the question is the equity, and as Justice Lukert asked, it's a structural change that was done. So how did that make it more fair? Where did 97, 95, 92 come from?
The point that I guess, and I don't know if this really addresses directly what you've asked, but the point I think that we're attempting to make is that the distribution didn't change.
What had
Not
to
that the
change
formula
when-
didn't change.
It
That-
had to change when you
Yes,
say you got X and now you get 92% of X.
the comparison, I think, and maybe this is a very fundamental point upon which there is disagreement, I think the court's going to have to decide, and that is the comparison on what the districts are doing across this distribution. You know, we have different AVPPs, and if those stay pretty much the same, so that each district has pretty much the same purchasing power, and if it's within the boundaries of the school districts must have reasonably equal access to substantially similar educational opportunity through similar tax evidence, which is 298 Can 1175, then it seems to us that we have satisfied the test and cured the deficiency and substantially cured it.
Well, you keep
And-
saying it's the distribution that matters, and maybe I'm being obtuse myself about this, but I don't see how you didn't change the distribution. The legislature went to a 97, 95, 92 on down, and that's okay. That's a choice that they can make, and what I'm interested in knowing is then how that was felt to be those numbers. Maybe they came out of the air, but I assume somebody had some reason for them. If you know if that's part of the record, where did that come from, and how does that contribute, or did it contribute to a more equitable distribution to satisfy the test in Gannon?
Well, I don't know that there's a way to reconstruct when a legislature makes a choice precisely what its reasoning is, and I don't know that that is even an appropriate area to go to. But my thought is,
Well, I'm saying I don't care how,
Yeah.
if you know how they
Yeah.
got there, how that contributes, in your argument, in your opinion, to
it is
more equitable.
it is because the additional 140 million, actually that's a couple million more than what the legislature was told it needed to do, was sufficient to create equity. You know, when the hearing took place,
Well, fully
Shortly
funding was
after.
the safe harbor. That was one of the options laid out in Gannon 1. And then and it looks like a pass was made at that, and then a different choice for whatever reasons was made, but that takes it out of that and puts it into a different category.
the safe harbor argument, and I don't find that in Gannon, but that is troubling to the state from the standpoint it suggests that there could be a funding level that is unconstitutional that the court endorses as being proper. I don't think it's a safe harbor. I think it is a statement that this is what this court has found based on the Gannon evidence is sufficient to create to correct the constitutional infirmities, and that I think is what the legislature understood as well. Then, when the
Counsel,
legislature,
Gannon's conclusion is pretty clear. that if there's full funding for capital outlay and the supplemental general state aid, the panel's job is done.
And I think, Your Honor, that's right. It is, as we'd understood, a statement that you would have cured if you had full funding.
I must have misunderstood your argument. I thought you said that was not any place in Gannon.
No, the safe harbor wasn't. The suggestion, and I may be
What
getting
is
language
the
from safe harbor.
Safe harbor is full funding.
Safe harbor
the
implies to
formula.
me that...
I'm sorry.
I apologize. Safe harbor implies to me that that is a level of funding that would have otherwise been unconstitutional, but we'll overlook it on this occasion. I don't think that's what Gannon said. I think...
But that formula is unequal. The 81.2 percentile by structure creates an inequality.
Well, the formula has always been unequal.
I don't care about always. I'm just saying that isn't, when we talk about zero tolerance, that formula that we approved did not have zero tolerance to inequality.
The formula that you approved, whether you call it safe harbor or not, had embedded in it what you would call to be unequal treatment. You still had a Burlington that had the ability to raise more per kid than you did Fort Leavenworth.
Exactly, and so we implicitly found that that inequality was reasonable and did not create a unconstitutional inequity. Would you concede that that's a reasonable inference to draw from Gannon 1?
That's the inference I would draw.
And so then the question becomes, we determined that was reasonable inequality. What evidence did the state present to the panel that the new structure was a reasonable inequality?
Well, Gannon also instructs that if you do not fully fund, then that doesn't mean that, and if you fund to some lesser amount, then you apply the test in Gannon. And when the legislature then makes the choice not to fund to the amount that had been endorsed as being constitutional in Gannon, the question has been why? And the answer is because of things that have nothing to do with equity. So if you no longer, if the bump up under the old formula would have generated the obligation to pay additional aid, but for reasons unrelated to equity, unrelated to trying to even out that distribution among the districts, then it follows that we have done everything that Gannon wanted to do.
I think the motivation to change the formula really doesn't matter. It may have been that the formula was changed for reasons not related to equity. We, concede that. But if a collateral effect of that change is to affect equity, then we have a constitutional problem, don't we? And isn't that what happened?
Well, I guess I have to step back and make two comments. One, when I think this court in the past, in Montoya and Gannon and otherwise, has discussed equity, it has not equated equity with equality or absolute equalness. And so if there is a change, as you point out, that impacts equity, then clearly the court has, as it's found this is a judicial issue and ought to be involved, needs to step in and act and analyze whether or not there's been substantial compliance. But that begs the issue, which is whether or not you have the inequality that's unconstitutional under the Gannon test.
Well, let's look at the capital outlay, because I think the numbers are easier to talk about there, frankly. The formula changed so that under the previous formula, there was at least the theoretical possibility that a district would have an equalizing effect up to 100%. That changed so that the cap is now at 75%. And I think in reality, the numbers were that one district was at a 90% level under the previous formula. That district now falls to 75%.
I'm not sure that under the previous...
I mean, obviously, the range, I think, is that low district with equalization is getting $345 per pupil. The high district without aid is getting $3,588 per pupil. Is that an equitable system?
Well, first, capital outlay is a tricky thing to talk about for a couple reasons. First, it is an add-on to your mill levy. So you raise 8 mills or 4 mills or whatever, and then what you get is to supplement that. And as you point out, whether it's 75% or whether it's 90% or 50, so
And
forth.
those numbers I just showed were districts that were at 8 mills. I
Yeah.
think I left that out.
So that, and Galena, by way of illustration, has always been talked about as being the poorest district. I think Fort Leavenworth is ignored because it gets the military sort of funding. Galena doesn't have any capital outlay levy, so it doesn't get any aid. It made that choice, which is what makes outlay a little bit different creature. Whether you want outlay or need outlay is dependent a little bit on whether you have new buildings. In Galena, they have a bond and interest issue, so they've got relatively new buildings, and they perhaps don't need that amount of aid. It's also a function of, for your mill levy increase, what's the bang for your buck? So if 8 mills doesn't raise very much, even though you get an additional 75% on it, which the court would have found was acceptable under full funding, it is maybe not that great a motivation to raise capital outlay. What we look at is that historically, when there has been an allegation for capital outlay, and in fact in the pleadings asking for, in the pretrial, or asking for recovery capital outlay, everyone was talking about a bulk figure, about $25 million is what was needed to bring about and give the equity that these various districts have, who have each a unique decision to make as to whether they want to have capital outlay or not. And what the districts did, or what the legislature did in this instance, is came up with, when the dust settled, $27 million, actually a little bit more than that, because they forgave some in additional capital outlay aid. So I can't say that it is because of the change, whether it's in structure or in actual funding, that creates a situation where you don't have the reasonably similar access and opportunity in the language found in the Gannon decision, which is the test I think you have to go back to.
But what's the evidence that it did meet the cure?
Well, first I think I want to talk about the premise of that question. In Montoy, when we were looking at whether there was substantial compliance or not, I think the court did give deference to the legislature's both actual and presumed findings of fact. In Montoy, they found substantial compliance based on a report from the legislative post-audit that was not assessed by way of evidence, was not quality of evidence, but was looked at as legislative history. The legislature had adopted things that weren't quite what the LPA had recommended, and yet substantial compliance was found. So I think historically
But
there's always been...
we have a distinction there. Montoy didn't have a panel in between the legislative act and the court, did it?
It did not.
And we gave the direction to the panel, the district court, that it must ensure the inequities in the present operation of the capital outlay statutes are cured. And so it was incumbent upon the state to prove to that panel that those inequities are cured. And what we've asked in a number of different forms today is, what is the evidence that the state presented to the panel that it ignored in finding that the state did not cure?
And when we trace through the language in Gannon, identifying what was found to be substantial competent evidence to support the inequities being an unconstitutional, we compared the results in fiscal year 2015 to what had been found. And they showed the sort of changes that established the cure with the $140 million. They showed the reduction in mill levies, obligations at LOB. They showed increased available monies to the districts. The formula change itself, one of the arguments that had been made in Gannon, one of the findings that had been made in Gannon was that if you have a formula and you don't fully fund it, that's an admission that there's some inequity here. Well, now we've got formulas that were fully funded by the amendments.
So just so I'm clear, your position would be if you dropped the formula to rock bottom and you fully funded that formula, your position would be, well, we're equitable?
No, not necessarily, but I think your point is a good one, and that is that suppose we did away with all local funding, then we wouldn't have any aid. That would be equitable. It is the distribution that we're talking about.
How would it be inequitable?
It would be equitable. I'm sorry.
It would be equitable. Okay,
Yes.
I misunderstood.
No, it would be equitable. It's the distribution we're talking about, not the adequacy, I think. But yeah, I suppose one could conjure up a set of circumstances where that something short of doing away with all of local funding with a drop in aid could be unconstitutional. And in fact, I think that's what Gannon found. The question is, did we cure it? Now, in Montoy, they gave deference even in entering the cure to the legislature, in recognition, I think, that there is almost an impossibility to decide these sorts of issues as an evidentiary sort of trial matter. These are policy judgments that have to be made. And as a policy judgment that have to be made, there has to be some sort of latitude given to the legislature. You know, local funding of schools and local control attributed to that local funding, by necessity in every arena, when you talk about local funding, has resulted in some districts, because of their cash wealth, some taxing entities, because of their cash wealth, having an advantage over others. And the court has never been troubled with that, and rightly so, because of the importance of having the ability to have local control.
And when you're talking about local funding, you're talking about over and above the 20 mills. Just so we're clear, the state's
Yes.
portion of educational funding actually comes from real estate and property owners paying 20 mills. That goes into the state.
That's
So
correct.
It's property taxes that pays the state's share of education.
It is the local,
basically.
Yeah, it is the local funding, whether it's by property tax or otherwise, that is granted through the system as part of school finance to local districts where they have discretion to raise their own funds.
Well, now that you've changed the lens a little bit, I want to, you're about out of time, and I want to move it to a point that the Shawnee Mission School District made in its amicus brief, and that is that the individual elements, instead of focusing and applying equity to the individual elements of the funding scheme, we should look at the total educational opportunity and in terms of per pupil funding and the total tax effort, kind of a more holistic approach. Do you think that's a valid way to look at this in terms of equity?
I don't. I think this court has pointed out that there is an intertwining between equity and adequacy as it concerns the issues before this court and as it concerns what were found to be the inequities in Gannon that have to be cured. I don't see there is a relationship there. What I thought was interesting about the Shawnee Mission District's analysis is that if you look at their charts and you compare what the dollar figures are per pupil, when you are only looking at the levies that are the 20 mil and then those LOB and outlay levies, that the numbers show that Shawnee Mission's per pupil numbers are a little bit less in terms of what they can raise per mil than the other districts who are in a situation where they are less wealthy by way of property. And I think that would suggest that yes, we have what we think is in place, which is with the additional $140 million, we've got a system that is equitable under the standards imposed by this court. And I see I'm out of time, so I'll answer.
Didn't
I've
the
got a few
panel?
more questions,
Yeah.
so.
Didn't the panel look at that total educational opportunity issue though when they talked about the inequity caused by the loss of the weightings and the change of the formula in that way?
The panel did, yes, Your Honor. I
And
don't
isn't
think
that true? I mean, if you look at the total, or why is that not true if you look at the total educational opportunity?
Well, I think that the panel exceeded its mandate in getting to that. But setting that aside for a moment, the question still goes back to the test. Yeah, there is now, when you have going forward in this year and next year, a freeze, I think is how it's been described, on funding. There are some districts that do better and some districts who do worse, depending on what the enrollments are. We have the actual enrollments numbers now. They're not in the record, but we had argued that it was speculative and that it was insubstantial, and I think the real numbers point that out. So, yeah, there'd be a change, but I don't think it's substantial enough to be of a constitutional dimension.
Several times I've heard you say it's not the formula but the distribution. I'm not sure I understand exactly what you mean by that. Are you saying that as long as we have a graph and the shape of the graph doesn't change, we're okay?
I'm saying, as I understand the test in Gannon, that if you have funding that allows districts an opportunity that is consistent with what we found to be full funding under the old formulas, then that is equitable. And the fact that under the old formula that you could have an artificial spike or you could have artificial or increased uses of mills levies that are unrelated to whether one district as to another are able to provide a similar educational opportunity, then that's unrelated. And if I said the formula is unrelated, I don't mean it. The concept I mean to imply is that we're talking about the distribution, not data points within the formula.
And tell me how we get away from spikes in AVP under any formula that uses AVP. I mean, isn't it just that we're changing the point from 81.2 to a different point?
Well, I don't know that there is a better way. I know that right now that's under the grant funding, that there's a hope to be a pause in everything, and that they're looking at other alternatives.
But as to this formula, what did that really, how does that, any formula, affect or improve equity?
Well, the formula has as its predicate that what we need to do is come up with additional funds for some districts to assist them so that they can supply a similar educational opportunity. Trying to figure out what that number is and that educational opportunity, and to assist them in relation to those districts who can raise other capital outlay. What that formula might be, I can't say exactly. I can talk about the present in terms of making it better than what the present system is under Senate Bill 7. What I can say is that Senate Bill 7, with its formula as implemented, does not change that distribution. That it responds to artificial circumstances that would have required payment of more money, but it does not, the payment of more money is unrelated in those circumstances to trying to do what we were trying to accomplish in the beginning, and that is to get a bundle of money to different districts to try to make their opportunity similarly the same as other districts.
And as I understand it, to make that point, you rely on your Appendix B to your brief? In large part?
Yeah, Appendix B to the brief, I think, is the data that was supported and provided to the district. I think actually the underlying data comes from the exhibits in Appendix B, which, if I remember correctly.
That's what I was going to ask us. Well, what is Appendix B? Was it an admitted exhibit at trial?
Appendix B actually was as part of proposed findings of fact. The data is from exhibits that are admitted in trial, and Appendix B, as I remember correctly, calls out what those exhibits were. Maybe in the brief themselves we set out what the exhibits were and give the record reference to those exhibits.
So it's a demonstrative exhibit that was submitted to the panel?
Yes.
Can you explain to me why on each page the first 5 districts are repeated? Does that go into the calculation and skew the calculation?
that's probably has to be more to do with the way that it's printed out when you use the Excel spreadsheet.
Yeah, I'm just
But-
trying to figure out what the authenticity of and reliability of the exhibit is.
The exhibit can be replicated easily enough by using Excel, which is what it did. It took the data from the exhibits and then plugged in the formula that each side has been using, and it spits out what it spit out. I'm trying to find my copy of it to try to understand what you may be talking about. I don't have it in front of me. It doesn't make any difference. You got. I'm not seeing it in the drawings, or at least the figures themselves, Your Honor, so I'm not sure what you're talking about. On pages 21 and 22 of the brief, I don't see the repetition that you're talking about.
Counsel, who prepared Exhibit B?
Exhibit B, my office did. Oh. Okay, I see what Exhibit B is, Your Honor, and I'm not. I'm not sure that I understand the repetition you're talking about.
And just if you look at each page.
Oh, I see what you're talking about. No, I do understand. It depends on how they're ranked. Each year there was a change among the various districts in the AVP. Some would hop up, hop down. And so I can't tell you from looking at this which year is which year, but what you have is the rankings will go up progressively, either whether you're looking at fiscal year 2015, which would be the first page, or progressively to the next page. And so you need to show that in order to represent how they move up when you get your two figures together. I'm guessing that doesn't make any sense.
That's okay. I think as long as we know the source and where
Yeah.
it came from, we can maybe.
Let me ask you about the 2015 session. At the beginning of that session, as I understand it, the governor imposed allotments, and as a part of that process, reduced the base state aid per pupil by a certain amount. Is that correct?
Yes.
And the effect of that would have been to reduce money to all the school districts, correct?
Yes.
And what the governor recommended and what the legislature did was move equalization aid money over to the budget so that, in other words, it restored the base state aid per pupil by taking away equalization aid. Is that correct?
I think that's the result. I'm not quarreling with that being the result. I don't know what the motivation was.
And doing
for the
it that
legislature.
way affects only the poor districts and not the wealthier no aid districts, correct?
Doing it that way would affect the equity, and it would affect those districts that are the 81st.2nd percentile and under, yes.
And how is that fair?
Well, if the premise which we offer is that there was a spike only for reasons that were unrelated to equity at that data point, that 81st.2nd percentile, then it is fair in that you continue to have the equity with the new formula, but what you've done is given back to districts monies that they would want to have of that $27 million.
And where in the evidence is there some offer of proof that the way to characterize the increase in the assessed valuation was not related to equity? I only see that as being the argument of counsel and not evidence that was produced before the district court. Is that correct?
I think that's right. That's argument of counsel. I think that you look, again, when you're dealing with legislative conduct in their motivations, I don't know that you can find evidence to say this is specifically why it was motivated or not motivated.
But even beyond that, if we're to say that this increase is something that doesn't affect equity, I mean, there are all kinds of school finance guys that'll come in and say one thing or the other. My point is, you didn't offer any evidence to support the characterization, correct?
That evidence was not supported by any sort of expert opinion, yes.
Moving over to Senate Bill 7, I'm a little unclear from reading everybody's briefs about what can occur now that we're in the block grant world, okay? And my question is, can school districts still increase their capital outlay mill levy or their local option budget under the block grant system?
Taking it one at a time, on capital outlay, if they have a resolution in place that allows going higher, as of, I think, last July, my understanding is they can increase it. So if you have a resolution that says that we have the right to raise 8 mills, even though you've only raised 4, you can raise it. What you won't get is if you raise from 4 to 8, equalization on that
Yeah,
increase.
it becomes unequalized revenue raising, correct?
That's right. As to LOB, there was a window, again, to have an election to be able to go up to the 33% number that has been closed. I can't tell you at this point how many districts elected to do that or not. And so there would have been a window to increase, but that I don't think you can increase LOB if you chose not to at this point. It has the same effect in terms of the equalization.
And if enrollment increases or decreases, you get the same amount of money, right?
That's right.
And if the characteristics of the students increases or decreases, in other words, if you get more difficult students to educate, you don't get any more money, correct?
Well, you know, the weightings, of course, go to a variety of different factors, as you're aware. But the weightings, if they change, whether it is a situation that would have, under the old formula, required more aid to be paid or less aid to be paid, the new formula does not apply to that. So in your scenario,
the answer is yes. I mean, if I get more students who are more difficult to educate and would have gotten a weighting to represent that increase in educational need, I don't get that under the block grant, right?
you don't get the additional aid for that. That's correct. I don't see any other questions, so I'll sit down and let Mr. McAllister make his argument.
Any further questions? Thank you, counsel.
Mr. Chief Justice, and may it please the court, my name is Steve McAllister, and I'm here representing the state of Kansas. This morning, I am addressing only remedy issues with respect to the panel's decision. With regard to remedies, of course, you wouldn't have to decide any of these if you agree with Mr. Chalmers that the state has substantially complied. But for the sake of argument, assuming we get to remedies, there are 3 primary errors in the panel's decision. The first is, to be honest, I've never seen an opinion amend statutes the way the panel's decision does. You start about page 65 to about 75. It looks like a legislative markup. They literally put sections of the statutes out there, draw lines through parts that they say are no longer enforceable. It's a very unusual effort, to put it mildly. The second thing the panel did, there's an error, and I will return to each of these in some detail, but the second error would be the purported revival of the prior school finance system when the legislature has enacted Senate Bill 7 and made very clear that it did not want to continue with the prior system. And the third error is the mandatory, injunctive, virtually mandamus kind of relief that the panel purported to order, directing various state officials that the panel ordered be brought into the case to, in essence, disperse state money, contrary to legislative wishes. Let me take each of those in turn, but I would start with a premise of I think I'm right in saying this, that this court has never gotten to the point of injunctive relief in a school finance case. The court has made declaratory statements. In Montoy, it said, not good enough, try again, legislature. Eventually it said, we think it would be this amount to satisfy constitutional requirements, and then we finally got to substantial compliance in Montoy. But this court has never enjoined state officials to actually spend certain money or do the kinds of things the panel directed, and that's the traditional practice. If you look across the country in terms of state Supreme Courts that have dealt with school finance, it's declaratory, and I think that is the most respectful way for the two branches to interact, the court to make clear what it thinks may be necessary. The legislature then has a chance to respond. The court then evaluates that response.
So the Supreme Court issues an advisory opinion on constitutionality of the legislative enactment?
Not on SB 7, I don't think at this point that that's necessary, but what I'm saying is in Montoy, the court said, when the legislature responded, the court said, we find problems. The legislature responded, the court said, your solution does not cure the problems, basically try again. The legislature did try again. The court then said, we think it would take something on the order of $850 million, at least over 3 years, to bring the system into compliance. Sent it back to the legislature, did not enjoin anyone. It declared what would cure the system. And if that's advisory, then that's what was done in Montoy. And then the legislature responded, and the final round, Montoy 4 as we call it, was a determination of what they had done was substantial compliance with this court's directives.
Aside what may be better practice or the more civil means of operating between branches, are you saying that this court does not have authority to enjoin the enforcement of an unconstitutional statute?
No. I mean, I would not suggest that at all, Your Honor. What I'm suggesting is in this particular context, declaratory relief, at least with respect to the equity piece, if it's not been cured, then the response would be to tell the legislature why it has not been cured and give it an opportunity to respond. So my suggestion would be, if the court goes in that direction, to issue an opinion that tries to give guidance to the legislature and then perhaps stay any decision or further action for 6 months until they can get into session and let them address what it is. That's why I would also argue the effort to revive the current system by the panel is erroneous. I think it's hard to read the record and what's going on out there and not think that the legislature would not want to simply reinstate the prior system if SB 7 is unconstitutional. Now, no one wants the schools to close or not be funded at all. But the whole point of SB 7 is to give the legislature a chance to evaluate the system. And I think that's not only appropriate, but in many ways laudable to take a look at our system, which has critics on all sides of it. It's extremely complicated. I don't understand it. I think Mr. Roop and Mr. Chalmers do. And I'm not at all convinced it's the most efficient, fair, and reasonable way to fund Kansas schools. So it's an appropriate endeavor to say we need a 2-year pause to try to find out if there's a better way to finance our school systems in compliance with Article 6.
Mr. McAllister, if we've determined that Senate Bill 7 really doesn't do anything more than carry forward the constitutional infirmities that were already found, are you saying that we should allow an unconstitutional statute to continue for a couple of years to let people work on it?
Well, I think effectively what I would say, Your Honor, is that you would, if that's what the court decided, that in essence, what I think you'd be saying is if the initial $140 million additional money that went in, which still is present in SB 7, is not a cure of the equity, and SB 7, in fact, in some way increases or continues the inequity, at most a declaration that that is the situation, and hopefully some guidance as to what would improve or work to satisfy the Constitution. And then I'm suggesting a stay at least of of several months. So you've got a funding system that's operating, but you give the legislature a chance in the next session to respond to that decision.
Let me ask you about that. It seems to me that regardless of whether there's appropriate separation of powers kind of authority to do what the district court did, that its motivation, it seems to me what they said was they're afraid that having made the determinations that they made, which is that Senate Bill 7 is unconstitutional, that really it's faced with coming up with some kind of a remedy like it did, or shutting down the schools. Why aren't those the only two options, particularly given the non-severability provision that's in Senate Bill 7?
Well, again, I mean, that provision is there, but I don't think that anyone wants the schools to close, and the legislature.
How can you read that section? And I mean, it seems to me you read that section and it says the state believes that if the enumerated sections, any of those are found unconstitutional, that the whole system's null and void. It seems to me that's the state saying that the kids should stay home tomorrow, if that's the court's ruling.
Well, I think that's the state saying it does not want to continue on with the current finance system, and it wants SB 7. I think their good faith effort here, really, to be fair to the legislature, was to try to hold people harmless. They knew it wouldn't be perfect, but they had put the additional money in. The idea of SB 7 is everybody gets no less than they're getting now for the next 2 years. That turns out probably to the benefit of several districts which lose students, and maybe to the detriment of a smaller number that gain students. But that's not an unreasonable choice to try to buy time to study the whole system. So I guess if you were to say as a declaratory matter, that system is unconstitutional, again, what I would suggest is the court could declare that, but stay the effect of its order so that the system, the funding systems remain in place, but the legislature then has an opportunity to decide how to respond to such an order.
I can't get that out of the language, though. That's my problem, because when I look at it and it says, if sections 4 through 22, if any of them are held to be invalid or unconstitutional by a court order, well, if the minute we say that, isn't the state's position that the day we say that, the next day the kids don't go to school?
Well, I don't know that that would be the case. I mean, you would knock, even if you assume you knock out the funding system, I would assume the schools have money. It may soon become an issue, but it would not be immediate that the schools would have to close. And many of them have substantial reserve funds as well that they could continue to operate. But so I understand that is a very straightforward way to read the non-severability clause. I guess what I'm saying is I think the legislature's intent is to get away from the old funding system, and they want time to figure out what would go in its place. So SB 7 is a reasonable effort to try to hold status quo roughly while that happens. Again, the legislature here, I think, in good faith, is trying to consider whether the current system really serves Kansas best. And one of the problems with the panel's approach to this case is it seems the first decision and this decision both essentially seem to constitutionalize the current statutory scheme, because the remedy in both instances has been fun to what that scheme said. But this court in Montoy, maybe it's not quite accurate, but said at the end there may be hundreds of ways to create a system that would satisfy constitutional requirements. And if that's the case, then the legislature ought to be able to look at other possibilities that would be a different way of coming at this, but still satisfy.
What prevents looking at different possibilities while the current plan is still in place? That's what I don't understand, is this need to suddenly stop, put in some sort of stopgap that they think meets the needs of the districts throughout the state and is equitable and is adequate, instead of just letting this continue and study. I don't understand the need to just stop in this kind of breathing period, this timeout as it's been called.
I think, Your Honor, if I may be speculating a little bit here, but I would say one reason they may have made this choice, a very sensible reason, would be budget considerations. Simply, they want predictability over the next 2 years, and with the current formula, there is variation, and some things may continue to increase. And so if they know what they are budgeting for, as we all know, we're in fairly tight budget circumstances right now, so predictability over 2 years for what is the single biggest portion of the state budget is of value to the legislators as they try to then figure out what to do going forward.
Counsel,
Go ahead.
I had a question going back to the remedy. I understand you believe no remedy is necessary, but assuming that we find that it is, I understood you to draw an analogy between what we did in Montoy and what you think should be done here. Is that a fair statement?
That's a fair statement. That in terms of approach to remedy and relief, Montoy is the better approach. It's the majority approach across the country, whereas what the panel did is a very unusual approach and got the court way more involved than typically has been the case in these situations.
But let's walk through Montoy, and I'll call it Montoy 2, which was the opinion released in January of 2005, in which this court said basically you're violating Article 6. It's constitutionally infirm, fix it. The legislature then made an effort to fix it, but they did not receive any specific guidance in this court on a monetary amount. So it then came back up here, and in Montoy 3, we said you missed the mark. And if you need specific guidance, here is the specific mark you need to reach. A special session was called, the legislature then came up to that specific mark. Do you have any problem with that procedure?
Well, I think as a matter of remedy, that would be much better than the court stepping in like the panel purported to and trying to dictate that these funds actually be transferred and so forth. Because as happened in Montoy, the court did suggest an amount, but it also paid deference and gave respect to the legislature, and the legislature said, we will try to get to that amount. It may take 3 years, not 1 year. And the court said that's substantial compliance. We think the legislature has acted in good faith here to address the situation. So the short answer is yes, basically along those lines, because one of the problems about this case, and it's going to be a more difficult problem in the adequacy piece than it is in the equity piece, is the legislature even really knowing, any of us knowing, what it will ultimately take to make the system unconstitutional. So in that sense, the more guidance from the court that is provided, it at least makes the conversation much easier, more clear. And again, I think the Montoy experience is somewhat evidence of that. When you just said it's not constitutional, fix it. They tried, but they weren't sure what the target was.
So to carry that further, if this court were to decide that the cure was not effective, legislature, and we're sending it back, try again, is it your recommendation that we put some sort of specific guidance on that, i.e. a particular number or particular range?
I think that
what you're saying?
would be helpful, or we may just be back here again arguing about whether whatever response comes was substantial compliance or not. I would also suggest in that regard that at this point I don't see any reason why this should go back. I do agree with Mr. Roop. I think he agrees with me on that from his brief. It should go back to the panel. At this point, if the court is to say it's not substantial compliance, I don't think there's anything for the panel to do. Then I think it's time for the legislature to have a chance to see that, consider it, respond to it. And then if anything further is to happen, it would come back to this court. The panel doesn't really need to be involved at this point if we're purely into the remedy issues.
Well, Mr. McAllister, I'm confused. What was unclear in Gannon 1 about the statement that if the legislature would fully fund the provision that it had in place, which incidentally, you said the last time we were here, that's not in play. We're only talking about dollars. We said fully fund that, and that part of the lawsuit is over. I don't know how we can be any more clear than that. And so now you're asking for guidance, and I'm a little unclear about what it is you think the state needs.
Well, one thing, Your Honor, is what I think the opinion actually said is if you fully fund, then the panel need not take further action or something like that, which is what the panel in essence said in June of last year. To 2 points about that. So one is the legislature, in good faith, believed it had fully funded. The reality is the Board of Education gave them numbers that told them you need $130 to $140 million to fully fund this. That was the information they were initially given.
Counselor, that's not right. I mean, you guys have said that, so much that it becomes frustrating to hear. But what was clearly said at the hearing and in the testimony was that the $134 million was based upon enrollment from the previous year and from the assessed valuation per pupil from 2 years ago, and there was still an unknown about how the districts would act once they were given that authority. So everybody knew that there was a lot of play in the joints. And nonetheless, Mr. Chalmers got up to the tribunal and said, we will fully fund it. And he explained the process for a supplemental appropriation, said, we're going to do all that. And then they didn't do it.
Well, and I'm saying, Your Honor, the legislators were not part of that hearing, and what I'm talking about is what they were told in the spring of 2014 when they were responding to Gannon.
What they were told was this handout that's in evidence, and that handout says, here are the hypotheticals that we've had to use to make an estimate as to what it would take to fund the formula using this old data. And then, like I said when I started out here, the thing that's sort of flabbergasting to me is that at the hearing in May of 2014, Dale Dennis is telling you that one of your hypotheticals is already low and needs to come up. And a light bulb should have gone on for somebody that says, well, we know that 134 million isn't the right number and it needs to go higher.
Well,
and no one did.
The light bulb did come on in the next legislative session when the legislators realized that number was going to be about $60 million higher. And I would come back to...
But everyone knew that earlier than that.
Well, but after, with all due respect, Your Honor, I don't want to belabor the point, and ultimately I'll accept however you want to characterize it, but my perception is at the time the legislature passed that bill in April of 2014, they genuinely believed it would take $138 or $140 million to fully fund it.
Based on what?
Based on Dale Dennis telling them here are the numbers.
A year earlier.
No, he told them in that when they were responding to Gannon. No, in 2014 when they're responding to Gannon, that the $140 million would do it. Now, it turns out, of course, he was relying on year-old data,
which he said he was doing.
But I'm not sure he said that to the legislatures. At least their impression was.
The handout says that. I mean, that's where I don't think you get a place to hide.
And that's
because it says this is what I'm doing, and in fact he testified that he was doing what he was instructed to do by the legislature. So I don't think you get to hide that way.
Well, even assume I don't get to hide, as you call it, that way, I want to bring it back to Justice Johnson's question about guidance. So the court clearly said in Gannon, if you fully fund what is the amount under the current statutory scheme, that piece will be over. But the court also said if you choose to do something less, the panel will make a decision, and certainly implied, if not explicitly suggested, that something less could satisfy the constitutional concerns. I don't think Gannon said you have to fully fund in order to satisfy the Constitution. So in my simple mind, I don't understand the numbers the way the gentleman on either side of me do. The question is, if it's $200 million to satisfy, the legislature went to 140. And then one way to look at this is the question now is that substantial compliance under the second option of Gannon? It certainly does not, I agree if you take your view, that it does not satisfy that first. But is it substantial compliance? Which my recollection is that's the language of Montoy 4, is not perfection, but it's substantial compliance.
But isn't that having it both ways? Because on the one hand, and I tend to agree that with what you just said about the idea that shooting for full funding and whether that they should have anticipated that or not. I mean, I think it's correct that it's not uncommon for there to be adjustments necessitated because of the timing of the legislative session and the budgeting time for the schools. But that aside, Once you shift out of that first full funding, as you say, then it becomes, well, all right, is it reasonable enough to be constitutional? And then, in answer to the questions about, well, what about what was done made it fair, get the answer, well, they put in $140 million, which is back to, well, that was the try at full funding. So, two different questions, but I'm hearing the same answer. Am I not?
Well, I think you're hearing, I guess, from me, what I'm trying to say is, I guess I'll just respectfully disagree with Justice Biles. My impression is legislators thought in the spring of 2014 they were providing full funding. Turns out they're not. And if they are not, then the question should be that B or whatever, I can't remember if it's 1, 2, 3 or A, B, C in Gannon, but it's that second one.
The next level.
Whether we're in substantial compliance, it's a reasonable response that improves the situation sufficiently that it's now equitable for constitutional purposes. And equitable for constitutional purposes, this court has never said means perfectly equal. That's probably an impossible standard for the state to meet unless we completely revamp the system in ways that, maybe that will be contemplated.
But the answer that comes back is numeric, not descriptive or conceptual. That's my point.
Well, and I think that's a difficulty with all of this litigation, to be honest. The court has to talk in words and describe and propose standards. The legislature is on the other side of the street over there trying to figure out how to come up with money to do things, and it is not always obvious. So if we drop into that second category again, if I were a legislator, I'm not sure I would know what. I know if I can fully fund, I'm in the first one, the sort of safe harbor as the chief described it. But if I don't fully fund, I don't really know whether 100 is enough, 140 is enough, 170. That's why I was kind of talking with the Chief Justice about the way Montoy worked. In some ways, is more effective, if you will.
But there's some inherent tension there with that deference that you talk about, because once you start saying this is the right number, as opposed to this is the concept that has to be reached, then you're back, arguably, from your point of view, I think, less deferential, because you're saying this is what it needs to be, as opposed to this is the standard it has to meet.
It is, but I think when you talk about reasonably equal access, for example, the kind of language that Gannon uses, that's not the most precise. I mean, lots of reasonable people would disagree about what is reasonably equal access. It could be there's only this much disparity, it could be it's this much disparity, and that's where I think it's very difficult for the legislature to know exactly what response will ultimately satisfy constitutional standards.
The
And if we
problem, counsel,
if we-
is that there's an evident, the legislature can ask people and figure out what's a decent way to do things. And a great example of that is the case, the school finance case from the early 90s. They want to decide, should we give additional money for kids that are at risk? Well, what's the definition of at risk? They look around and they see how other people do it, and they get different examples of things. And then, well, if we're going to identify kids this way, then how much more should they get? And you get information about how things are doing, and then the legislature makes a judgment call. And it's okay to make a judgment call, but you're doing it within the boundaries of some evidence, of some common sense. And that's what we're trying to figure out here. What was the evidentiary basis for the state to come into court and say, we substantially complied? And that's what we've been trying to get at all morning here so far. But it seems to be only that, well, we put in more money. And I get back to, Gannon says this is not about just more money. It's not about that. And so, can you point us anywhere in the record that says this is the information the legislature used to come up with this number so that it believed that this was curing the constitutional infirmities?
Well, I think, Your Honor, to be fair, this is my view of the story, is that when Gannon said if you fully fund, constitutional requirements are satisfied, again, you and I may just ultimately disagree, but the legislature thought it was doing that. When it realized that was not the case, it also has other considerations, budgetary concerns. They did not back out any of the 140 million. They just said we can't afford to go to the 200 million that we now see it's going to take. So that 140 million was a direct response to this court's decision. They thought they were in that first category. SB 7 is then the point I think you're getting at, is the legislature saying, we made the situation better, we did what we thought we could in response to Gannon, now we want to hold everyone harmless, just keep things level for budgetary purposes so we can plan for the next 2 years and know our obligation. But in the meantime, we want to do, I assume, exactly what you're describing, which is to look around and see what other systems are out there and see if there's a better way, a more effective or efficient way to do it. So I can't point to evidence in the record that they did that yet, but I do think SB 7 is the evidence that that is the intent, and they've got a commission or some group that's supposed to be working on this with all kinds of people, and I don't know where they are, if they've made any progress, but that is the goal, I think, is to do what you're suggesting.
You mentioned that none of the money was backed out. Where did the money come from to establish the emergency fund?
Well, I think that's going forward, right? I mean, I could be wrong about that, but I thought that was in the next fiscal year. I don't think the 140, so that would be additional money. But
where's it coming from? I mean, it's coming from the school districts. The money to fund the emergency.
I understand the emergency fund, but I don't think that money was taken out of other funds that the school district. I thought, as I understood, the block grant was to put them all at where they are, and then that's an additional amount of funds that are available for certain districts who think they have emergency
I
needs
understand
to go
it's
apply.
an additional amount, but I understood that it was a deduction of like 0.4 something from the school districts, and that's my question. Where did that come from?
I can't answer that question. I don't know for sure.
That kind of touches on a topic you haven't addressed that was in your brief about the scope of the remedy and whether it only covers fiscal year 15. Do you agree that the mandate is post-judgment compliance monitoring was what we asked the district court to do?
I guess I'm trying to understand post-judgment compliance in the.
After Gannon 1, that we send it back to them and the mandate and ask for them to monitor the compliance with a remedy.
Well, I think that I do think that Gannon 1 contemplated that the system would not be changed so that it would be easy to measure, in effect, whether the response satisfied it. And I do think the enactment of SB 7 complicates the picture in the sense of we sort of have this, the landscape has changed. And I guess the way the state views it is what the court ought to ask at this point in time is, did that response in 2014 substantially comply with Gannon and with the system that existed at that time, and leave for another day, if it comes, any challenge to SB 7 going forward? More likely, any challenge would take too long to work its way through, so that probably what we end up is a new system in 2 years, rather than, as the panel did, basically jumping in and trying to evaluate SB 7. Which again, there's a lot of problems with what the panel did. I mean, that was late, very late in the game, late notice to the state that it was going to get into some of that territory. I mean, it really wasn't litigated the way it should if you wanted to fully examine SB 7.
But if we would determine that they did not comply for fiscal year 15, we're still in a remedy compliance stage, aren't we? And doesn't that put us into class?
I understand that it could. I certainly see your point that if you think it was not compliance and the issue is what will it take to comply, then you might well be taking account of current circumstances to see what steps the state would have to take.
Do we have any further questions?
I want to move you back to the non-severability provision for a minute. In the context of school finance, where we have Article 6 that says the legislature shall make suitable provision for the financing of the educational interests of the state, can a non-severability provision that says if any part of this is unconstitutional, it's all null and void and the whole system just stops, can that provision even be constitutional, given the duty on the legislature to have a system?
Well, that's a fair question, and one, to be honest, I haven't really thought about. There certainly are cases in which courts have refused to enforce severability or non-severability provisions, perhaps for reasons like that. I don't know if a court has ever declared one unconstitutional necessarily, but
it'd be a breach of the legislature's duty to have a provision like that in there that basically says the whole thing blows up.
Well, and I think a couple things about Article 6. Of course, you're focusing on the shall. I tend to focus on the suitable, and the question is what's suitable. And I think the legislature's view is it has put a suitable system in place with SB 7.
But if you don't have any system, how can it be? It can't be suitable
If
you
there
have
is
no system.
if there is no system. But that, again, is why I think the appropriate relief would be to say, if the court thinks that it does not find SB 7 to be constitutional, but stay its decision, if you will, to give the legislature time to respond. Because I do think what the legislature was trying to say is we do not want to go back to the prior system, but I don't think they were saying we want to shut down all the schools in the event SB 7. I realize that could be potentially the effect, but I don't think that was really their intent.
It's certainly the fair reading, the plain language.
Of the plain language, I agree.
Okay.
I agree.
Do you think the case law that has developed regarding the enforceability of severability clauses applies to non-severability clauses? Do we look at it in the same way?
Well, I mean, I guess what I was thinking of, Your Honor, is examples of cases where there are severability clauses, and courts have said it's really not severable, but I think there are also cases where, maybe cases where they've said, the legislature says it's non-severable, but for a particular compelling reason, the court says we just can't give effect to that non-severability. I mean, I don't have citations at hand, but I do believe both kinds of cases are out there, not necessarily just in Kansas law, but in state law generally. So in a sense, I think the harder is when there's no severability or non-severability. Those cases are basically just trying to discern the intent of the legislature, but there are cases where courts have declined to follow a severability clause, and I also believe a non-severability clause.
Any more questions? Counsel, we've taken a lot of your time with our questions. Do you need 30 seconds to wrap up, or do you believe you've stated your position?
I think I've stated it over and over again, but I would say, close by saying, really, from a big picture sense, what the legislature did here is a dramatic improvement for the system in terms of the response to Gannon, and then a pause, again, trying in its view to hold the school districts more or less harmless by keeping the level of funding for the next 2 years so they know it's not going to be less, and then try to figure out a new system. And I think that effort is ultimately both appropriate and laudable, not something that should be criticized. So with that, I would ask that the court reverse the pen. Thank you.
Thank you.
Mr. Chief Justice, may it please the court, Alan Roop and John Robb for the appellees. I do want to do a quick reset and make sure we're all on the same page in terms of this being the remedy phase of this matter. Going back to your earlier decision some 18 months ago on the status of equity and the ruling of unconstitutionality, we're here today following up on the trial court, the panel's decision with regard to equity. Simply, this needs to be fixed. I've been in front of you 8 times, and there is a pattern here that I've noticed in the times I've been before you. The legislature strays from the funding and slips from their constitutional responsibility. The schools file lawsuits. The trial court examines, often determines that that is in fact what has happened. The state appeals, and the state comes before you and tries to protect their separation of powers and their appropriation ability. And you instruct the state what needs to be done. The next time, repeat the process. We think that this has gone on quite long enough. Casey Thal, who was a plaintiff in the Mock case in the early 1990s, is now 35 years old and has a couple of kids, lives in Olathe. Ryan Montoy of the Montoy decision was 7 years old when we filed that case in Salina. And today he's pushing 28, 29 years old. Luke Gannon was 10 years old as a 5th grader when the current case was filed in 2010, and he's now a 15-year-old sophomore in high school. We are going to advocate that this court take prompt action. We ask this court to compel compliance with this court's orders and with the Constitution. The kids of Kansas deserve nothing less. They've waited
And
long
what
enough.
do the kids of Kansas have now that's so deficient? I mean, if you look at the National Assessment of Educational Progress reports, Kansas ranks high when you compare it with other states across the country. So where's the deficiency? Where's the problem? What did Ryan Montoy not receive and the other examples? And what is Luke Gannon not receiving that makes this such a big problem?
As representative plaintiffs of kids in public schools, I will tell you what has been said before, and that is that averages tend to hide the problem. Most of our kids, you will hear from the people sitting in the back of the courtroom that are connected to education, do fairly well. The problem is when you look at the achievement gap scores that are in evidence, there are sometimes as much as 20, 25, 30% of children of color that can't do the math in 8th grade. And it's not all the kids that are doing well. It's the kids that we have a tendency to leave behind, and those NAEP scores may very well indicate how overall the kids are doing. But in terms of the 20% or the 30% that have the same constitutional right to an educational opportunity as every other kid, those kids are being left behind. We're here for those, that percentage of kids that do not, that cost more to educate, that need more resources to get even with the rest of the kids, and those kids are the ones that compel this court to act.
So what's squarely before us today, you see it more as an equity problem than, and I know we're not at the adequacy point yet, but.
Well, I don't want to forget adequacy.
I understand
I'll be back
that.
to talk about that sometime in the spring. But
Right.
in terms of equity, here's what I think happened. This court gave, and Montoy, I don't know which Montoy it is because we number them all differently, but Montoy 4, as I call it, really is your map quest for what needs to be done in this case. And you were explicitly clear in your Gannon decision as to what the safe harbor was. You told them, fully fund, you're in the safe harbor. The legislature made a choice. They chose not the safe harbor, they chose the wilds of the ocean. And the problem is, they are now in a position where they are trying to defend a system that is not constitutional because of the inequities, because of the differences in the property values, because of the differences in how much that money raises.
Let me tell you the problem I'm having with that argument. If we go back to 229, the formula in the 90s, we were equalizing at the 75th percentile. And at least as to LOB, it's not, the numbers aren't going to work for capital outlay, but at least for LOB, if you look at the 190 9 million or whatever it is that went into LOB, you get kind of close. I mean, and this is a little bit of a horseshoes kind of a tournament, but you get pretty close, it seems to me, to 75th percentile or above with what the legislature did. So if the 75th percentile was okay in the 90s, which it was, you know, why can't we use that?
Well, if my recollection's right, in the 90s, the approach that the legislature used was different than what the approach is in Senate Bill 7. And if you take your Gannon equity test and you apply it to what was done in the 90s, a flat 20 mills across the board to raise money for the state is an equitable system. And there was enough money in that system that the LOBs, which at that time were designed for extras, for additional compensation for teachers or whatever local school.
You and I might disagree about that part of it, but let's continue.
Okay. In terms of what the LOB could be used for, there was relatively little use of the LOB. But as the problem with adequacy evolved and the resources became less, it exaggerated or amplified the equity issues. And that's the problem here. So it's different than the 1990s in the sense that because of the inadequacy, we've got exaggerated problems in the equity area, and Senate Bill 7 did this. It didn't fully fund. It raised the LOB cap from 33% to 31%.
31 to 33.
31.
I'm sorry, 30, other way around, from 31 to 33. And if you use that what I call the false base, and the figuring on that, it really is closer to 38% that is the multiplier. It's still subject to the inherently unfair election process that we discuss in our briefs, and we showed you how property poor districts have a real gravity pull and keep the elections from being successful when it comes to capital outlay and when it comes to local option budget. And in the wealthier districts, that becomes much, much easier. They imposed a flat tax, that's my phrase, but the 0.4% to create an emergency fund is across the board, but it, like any other flat tax across the board, affects the people that don't have the resources the most. And then they only cut aid to the poorer school districts, telling them, to use the panel's language, telling them that they would be in a position where they had to cannibalize resources in order to stay afloat. That, and finally, and maybe first, they eliminated the weightings so that the additional resources available earmarked for kids that need additional resources in order to compete are now gone. And by freezing the funds, they don't take into account those districts that receive additional kids that need additional resources in order to compete and have educational opportunity.
So looking at that list of 5, on the one that you had about the unfair election process, that is a situation that existed or would have existed under full funding, right? Even if they had chosen, the legislature had chosen option A and fully funded.
Yes.
So why is it any different under the method that they chose?
Well, I'm not sure it is different, but under your equity test, the state was put into a position when they didn't fully fund. Under your equity test, they need to prove that there is substantially similar educational opportunity and reasonably equal access. And under the old system, there wasn't reasonably equal access.
So your answer brings us to a fundamental question of what is our point of reference here? Is it that if the state can show us that they would have gotten to the same point they would have had they fully funded under the formula, the prior formula, we would be done? We wouldn't even. Or do they have to show us not only that they have come to that level, but also have cured other inherent inequities that may have existed under the previous formula as well?
To me, it's as simple as if they had walked into the panel and did what they promised they would do, which is fully fund, the equity piece would have been concluded. The problem was they adopted Senate Bill 7, and they did these things that I just indicated. And so they were then taken out of the safe harbor and put into the ocean in which they had to defend, or they had to prove to you that their new system provided reasonably equal access, it doesn't, to substantially similar educational opportunity, it doesn't, through similar tax effort, it doesn't. So I think it's as simple as following the directions from Gannon and looking at it to see, did they fully fund? They did not. Did it meet the Gannon equity test? No, it doesn't.
Counsel, what if instead of property values having been elevated, they had declined, and the state considered that obviously in the formula, and now are fully funding? Would you be here today?
I don't know that I can answer that, because I'm here today because of what happened. And what happened was that they call it precipitous, but it was absolutely within the norm. If you look back to fiscal year 2011 through 2015, the variance isn't very much. I don't know what the answer to that question would be if they lowered the river instead of raising the bridge. I'm not sure we would be here, because they would have fully funded. But
Well, we said in Gannon that if you fully fund, the panel need do no more. And so if the property values, instead of elevating, had declined and the legislature fully funded, my question still is, what leg would you have to stand on to be here today arguing that it's inequitable?
I'm not sure we would be here today arguing that.
Because that is just a risk inherent in the system that school districts and others.
Yeah, but that did not happen.
I understand that. I'm just asking, are you willing to take the good with the bad?
Well, I think anytime the court says fully fund and circumstances change so they have fully funded, I'd be in a pretty poor position. I'd be answering tough questions from everybody in that situation as to why I was here. So I'm not sure we would be here in that situation.
Let me ask it a different way. What do we do now with the inequality that the state has admitted is in the system that we had implicitly approved, plus your alleged inequality with respect to the elections? What do we do with that?
Well, first I'll give you my political commentary for what it's worth. And that is, I don't think you take a system that has evolved over 20 years through a number of different lawsuits that has become a fairly good system and throw the baby out with the bathwater. That's what they did. I don't think and I think the panel is trying to put us back into the situation where the formula, if it is fully funded, tended to work. And I think this court has acknowledged that. So in terms of what do we do now, my suggestion would be, let's not go throw the baby out with the bathwater, which is what the legislature did. I say 4 things. Let's pay the mandated $54 million of equalization aid for fiscal year 15 and order the equalization paid at that rate for the current year. Order the block grants to be recalculated and redistributed equitably, that is, based on cost. Devise a more responsive system to ensure compliance, and my thought is that you've already done that. 4, order the state to pay attorney's fees as a consequence. Those are the 4 things that I would advocate be done. I agree that what the panel did was to basically roll back the clock and distribute the money under the old formula. That's okay. That is something within your ability to do because we are in the remedy phase. So you can do what you did in Montoy by saying to the legislature, this needs to be done by a certain date, and if it isn't, here is the consequence. That's what the remedy phase is all about, and that's how the Constitution, as I understand it and learned it, works. What I would suggest to you is that we have come to this point through about 10 broken promises by the legislature going back to the 1990s in school finance. Number 1, in order to get the case dismissed in the Mock case, the legislature instituted a $35 million levy to fund the system. And at the time the act was passed, spending and funding levels were in balance. But once the court dismissed the action, the legislature cut the legs out from under the system, lowered the levy to 20 statewide mills, which is its current level. And this decrease forced districts to start using more LOB in order to pay the way. Second, the LOB cap. At the same time that the state set the statewide mill levy to 35 mills, LOB was set at 25% and was slated to decrease as the base increased, and that was the design to enhance equity. The goal was to eventually eliminate that LOB, and after Mock was dismissed, the legislature removed the provision, making LOB a permanent fixture. And rather than eliminating the LOB, it has increased to 27%, 29%, and now, as we talked about, 31 to 33%. This doesn't take into account that 38% computation with the false base.
And Council, since we're here on equity, address, if you will, for me, the impact as you see it, since you've just talked about the LOB and that becoming permanent and all. I mean, so how does that overall affect fairness in ensuing years and now, since we're here now looking at equity?
Well, in terms of the impact on the plaintiffs, in this case, we put on evidence at the time of trial as to what impact that inequity causes, both by the variation in the property values, and we have evidence in the record of that, but also of how that impacts the kids in class. When Kansas City, Kansas loses teachers by attrition to the Blue Valleys and the Shawnee Mission districts because they can pay more money than the school district in Kansas City, Kansas. The record is replete with examples of how these districts that are property poor are disadvantaged in what kind of educational opportunity they can offer. That's one example. But
so you trace that causally back to LOB?
To LOB, capital outlay, and the deficiency in equity in the entire system. It's also an adequacy problem. I'm not going to talk about adequacy since you want to talk about equity, but right. that's like trying to separate the mist from the cloud sometimes. And in terms of the deficiencies in these school districts that are
Well,
property.
only if there's a structural fault with respect to equity in LOB, I guess that's what I'm asking, if that's what you're suggesting, if it is somehow structurally unfair or inequitable.
Well, I would tell you, in two school districts where one has high property wealth next door to one that doesn't, it becomes very obvious, because the attrition of teachers, the attrition of those kids that cost less to educate, the attrition of the resources put those schools in a position where they're not offering the educational opportunity that their neighbors do.
But that's why there was equalization.
Right.
Discretionary equalization.
I'm sorry?
Discretionary equalization, because not every school district has to have the same LOB. That's what you were saying about the elections, right?
Well, I would put quotes around discretionary, because it is.
Yeah, I understand what you're saying about it's necessary to run the school, but I think the question was, is there a structural problem? And I understood you to say that part of the structural problem is that it's dependent upon the local electorate, whether the state is making suitable provision for education. Wasn't that your argument?
Yes, that's
Okay.
the argument.
What comparative evidence do we have to look at? The state didn't use option A, so now we're trying to figure out whether school districts have reasonably equal access to substantially similar educational opportunity through a similar tax effort. Where's the comparison between districts in terms of the evidence? It wasn't put on at it wasn't put on at the 2015 hearing last May or June when you did that. You put on two of your plaintiff school district superintendents and Dale Dennis. So where is, I'm trying to figure out, and I appreciate that you're going to say that they have the burden of proof, but did you demonstrate that there wasn't reasonably equal access?
They have the burden of proof.
I understand that.
And if they don't put on any evidence, as I understand the burden of proof, the inquiry ends. So let's agree on that. And then I will tell you that in terms of the evidence we did present, we presented what was happening in the property poor schools. We didn't put on any evidence, we didn't put on any witnesses in terms of the wealthier schools. But this court has consistently said that money makes a difference in the educational opportunity. And what we did put on evidence of was the disparity in the money. And the
Say that
disparity,
again, I'm sorry.
the disparity in the distribution of the funds. And that disparity in the distribution of funds, when coupled to the principle that money makes a difference in educational opportunity, would be the evidence I would point to that we presented in the record on that issue.
Did I understand when, and I'm really going to be in the weeds on this one, but when the Hutchinson superintendent testified, she said, we're going to have to cut this and that, and 25 personnel are going to go, and we can't put a roof on, and that sort of thing. Did I understand that testimony correctly, that those cuts were a result of not getting the equalization aid that had been promised and that they had budgeted for fiscal 2015?
That's my recollection.
Okay.
Back to my list. In terms of the cost study with A&M, the 2002 legislature enacted legislation to say they wanted to study what the cost was. They got the cost. They didn't like the cost. They passed a statute saying they didn't have to follow A&M. At this court's suggestion, they did the legislative post-audit cost study in 2005. And when they got the results of that cost study. They didn't implement its recommendation, and they passed a law, KSA 46-1226, saying they had the ability to ignore it. Beginning in 2009, they began to cut the base. They stood here in Montoy and represented that there was a 3-year plan and that they would increase the base, and promised 4492, and what ended up in their 3-year plan was what was tantamount to $511 million in cuts, and ultimately the base is now lower than it was pre-Montoy. The CPI increase in 2005, they indicated that they, in securing the dismissal of the Montoy case, they adopted 7264C04, saying that total state aid would increase by at least the increase in the CPI. That provision was removed in 2010. Capital outlay equalization, 2005, the legislature added capital outlay equalization to enhance equity and gain the dismissal in the Montoy suit. And in 2010, they abolished it. First priority in budgeting and payment. Today, there is a statute that was adopted in 2005, 7264C03, and it promises that school finance would be, quote, given first priority in the legislative budgeting process and shall be paid first from existing state revenues, unquote. And you heard the state's attorneys here today saying that it was rolled back because of other demands. That statute says the schools should be paid first. Montoy phased in funding. They started in 2006 to adopt a 3-year funding plan and cut it within the 3rd year. Capital outlay and LOB equalization. In 2014, the court mandated the capital outlay and LOB equalization be funded fully. 2014, they adopted a bill, 2506, that and state's attorney represented they'd done that, but here we are today. We think, and it's hard to look at these facts and consider what is an exhibit in this case, a governor's press release, where the governor says he wants to adopt Senate Bill 7 in order to forestall the payment of $54 million and to postpone paying the schools. It's hard to look at that and come up with any other conclusion that somebody here isn't acting in real good faith. And your exception on the award of attorney's fees is when somebody acts in bad faith. So I would advocate that you use the Montoy decision, your Gannon decision, as the MapQuest for what needs to be done now. And if the legislature continues to act in bad faith, I think part of that remedy needs to include the payment over years of litigation to these plaintiffs for their fees. So my statement as to what we wanted, I have already read to you.
Mr. Root, may I ask you a question on that? You indicated, I think the second request was to order the block grants to be recalculated.
Yes.
Could you elaborate?
Basically, or along the lines of what the panel did. Recalculate the block grants based on what people received with the weighting, what districts received with the weightings, so that that money can be redistributed and do it with an eye toward what it costs to educate those kids that cost more to educate. So I think the point north on any recalculation has to be what it costs, including the inputs on what the school needs to teach a kid, and include the outputs on what that teaching results in.
How do we do that? I mean, I can understand how we could go back and revive the weightings and say, as enrollment fluctuates and kids come and go, that the budget numbers need to fluctuate. I can understand that part, but how do we do anything about trying to use, because I hear you trying to get into Augenblick and Myers and the other cost studies, and is that what you're trying to do?
The last thing I want to say is let's go have a cost study. That's another delay, and you heard the ages of the plaintiffs in these cases today. I don't think that needs to be done. I am biased in favor of the old formula, which, if fully funded, worked. So in terms of the old formula's weightings, which took into account the cost of educating kids that need additional resources, I think a distribution along those lines would be important. I think you also have the authority to do it in terms of the remedy phase.
But doesn't the legislature also have the authority to just throw out that formula and having, through the non-severability clause especially, they given us a pretty strong message that that's their intent?
Yeah, I don't think the legislature could adopt a law tomorrow that says we're only giving welfare benefits to white people. They can't throw out a system and create an unconstitutional situation. So in terms of what they did with Senate Bill 7, if I hadn't said it clearly yet, I'll say it here. It's not a cure. It's a poison. It has created more equity problems. So can they throw it out? Yes. But do they have to replace it with a constitutional system? Yes. And
don't they have a right to cure that new formula?
Yeah, but I agree with the comment by the justice earlier, that you don't throw out the system and then ask for 2 to 3 years to come up with a better system. You use the system you've got until and unless you come up with a constitutional system that is better.
What would satisfy you on the equity issue short of full funding?
Well,
and I ask that because jumping ahead to remedy, if we get that far, one of the counsel for the state had said, if you make that decision, please be specific to the legislature on what it needs to become constitutional. So what is your answer to that?
Well, I think the answer is full funding. I think you say to the legislature what you said to them before, but and then impose consequences. But if you're asking me if they topple to otherwise in the Gannon equity test, what would be fair? My answer would be if you adopted a statewide property tax and eliminated local property tax, that would be fair. And that is an option for them, but I don't see anybody talking about doing it. And what is needed is a system that is equitable.
It's your belief that we can mandate that the legislature pass such a proposal?
What I just said?
Yes.
You are in the remedy phase and you can give them guidance and you can tell them what they need to do. In Montoy 4, you told them an amount of money that they needed to pass by a certain date in order to comply. In the remedy phase, you can give what I would call MapQuest guidance to the legislature on what they need to do.
Well, my point is saying here's the amount of money that it takes. And when you talk about Montoy 4, I think that's what I call Montoy 3.
It's like daylight
Just so
savings
we're clear, in June of 2005, is that the one you're talking about?
That's the one I'm talking about.
There we said, here's the amount of money that it would take. But you're moving beyond that, it seems to me, by saying here is how you do this.
And that's what the panel did.
And you're saying that this court has the authority to tell the legislature, scrap this funding system, not the formula necessarily, but just how the money is provided.
Well,
That's your point?
You can tell them to scrap Senate Bill 7 and replace it with a system that does the following, and you can tell them that they need to point north and look at the costs of educating kids that need more costs, and look at the other problems that we've discussed with equity and cure those.
But is your position, getting back to my original question, that we could tell the legislature, you shall have a statewide property tax and do away with local property taxes?
I'm not sure you could say that, but you could say to them, you need to develop an equitable system. And you asked me what I would do to create an equitable system, and maybe I sound like I'm campaigning to get a place in the legislature, but I would adopt a system that was fair across the board.
Very well, thank you.
I want to be clear about what we did and what this court did in Montoy, because I don't think it's been properly described. In the summer of '05, the legislature wanted to buy another year so that it could do the legislative post-audit study. And this court said, well, you can have another year, but you have to put in this amount of money, a portion of the money for the coming school year in order to have that. Otherwise, we're going to go straight into whatever the remedy's going to be. Isn't that right?
We both had a front row seat on Montoy, and that's accurate.
Okay. So, but it wasn't, this is the number to make the system constitutional. It was a number to buy another year.
Yeah, and to do it by July 1.
Right.
Yeah.
Right.
Okay.
Right. Let me, I really got confused in the different briefs and then trying to look at the block grant statute. What authority, now that the block grants are in place, what authority do school districts have to raise their LOB? I know they're not going to get any state aid for it, but do they have any authority now to raise their LOB? And on the flip side of that, do they have any authority today to raise or lower their capital outlay mill levy?
I don't know that I can answer the question on capital outlay lower. Do they have the authority to lower? I haven't looked at that. They do not have the authority to raise on capital outlay. They do have the authority, or did for a period of time, to raise on LOB above the 33% or above a certain amount with an election.
Right, but that election had to be made before July of 2015.
Right.
So as we're here today, no school district has any additional authority to raise their mill levy.
That's correct.
And what about lower the capital mill levy?
Well, that's the one I said I haven't looked at that. I can't imagine anybody in our group of clients wanting to do that.
But if they can do it, they would still get the state aid that they received at the higher level, wouldn't they?
I suspect that's exactly accurate, the same as if they had a decrease in enrollment, they might receive the frozen funding.
Right.
Thank you.
Does that conclude your presentation?
It does, Your Honor. Thank
Do
you.
we have any further questions? Thank you, counsel.
Thank you.
This court has said, at least it's been repeated, that there are hundreds of different ways to properly and constitutionally fund education. I want to assure the court that there's been no conspiracy over 3 different governors and countless different legislatures to try to deprive kids in Kansas of their properly constitutionally guaranteed right.
Well, what respond to Mr. Roop's bad faith
Well, I think
observation?
Sure.
Here we have at least, I've been on the court 10 years now, and here we have, at least in my limited exposure over the last 10 years, 2 significant representations made to 2 different courts, one to this court directly, and that goes back to Senate Bill 549, which we talked about last time, that there was a promise made or commitment made, however you want to put it, that wasn't fulfilled. And here you made the exact same type of representation at district court that will go the full amount. I think the legislature deserves a pat on the back
I tell you,
What does a court do with that when it doesn't happen?
I don't retreat from the statement that I think the legislature receives a pat on the back. It responded promptly and in good faith. Dale Dennis testified that the numbers that they came up with at some difficulty, I mean, these are difficult budget times, but those numbers were not going to be modified much, that he thought he was very confident in his estimates. Even if he was reviewing the wrong data, it was the best data that was available to him.
He didn't say anywhere in that transcript that these numbers weren't going to change significantly, counsel.
I think he did, Your Honor. I remember asking the question. I think it's there. I think you'll find it at the tail end of my cross-examination or my examination of it. The point is, of course, that in each one of those cases where you talk about promises being made,
But those promises induce a court action. It induced us in Montoy to dismiss the case. Here it induced the panel to find compliance, and actually found compliance. And then it doesn't happen.
And then there were change of circumstances. And I think a lot of it was driven by the economy. And if the standard is a contract sort of standard, then I think the state has problems, but that's never been the standard in the Constitution.
I'm sorry, would you repeat that again?
I said if there were a contract sort of standard, if that's what we're talking about, then I think the state would have some sort of problem, I guess. But that's not been the basis in the constitutional arena. You know, we have formulas that were in place that are endorsed as being not constitutional, but as being substantial compliance in Montoy. Do we elevate that and enshrine that as a constitutional standard? Is that where we are to end all? Is what the state articulated it would do in Montoy many years after 1966, when the contract between the parties and the people was formed, saying we will provide this sort of education? Is that what the contract was meant? And I certainly know. I think the state has acted in good faith in these respects. They have fallen short of what they have said they would do, but they've had good reasons for it. And in the last instance, the good reasons was the problems with the economy, as well as changes in circumstances that increased what they would have to pay.
I guess I didn't see any condition when you said we'll go the full amount. I didn't see any condition. Well, it depends on the economy. It depends on elevation of property values in oil-rich districts. I just didn't see any conditions put on those commitments in either instances that I've been a part of.
I don't remember putting any conditions on that at all. That was the expectation at the time. The question was asked about post-judgment compliance. At least that's the way I phrased it. And I want to remark on that real quickly. And in the post-judgment compliance, we talk about a burden of proof that's been placed on the state, but then a lot of discussion by Mr. Roop and by this panel have been to equity concerns that were not present in Gannon. And what we are here to do is to analyze whether the unconstitutional equity concerns found in Gannon were cured, and not to talk about those things that go beyond that. Now, if you're going to talk about those things, then certainly the burden of proof is not placed on the state. It doesn't make any sense, and it seems to me an irrational solution to say that based on the burden of proof, conduct, when all presumptions are allowed to the state, that it be constitutional, becomes unconstitutional because the burden has shifted. How can the contract between the parties change?
Are you saying that because this court found that the inequalities or inequities present in the system then, in Gannon 1, were within reason, were acceptable, that then we don't add those inequities to any further ones, that we just ignore those when we make an assessment of whether the state has proved that the current system is equitable, constitutionally equitable?
What I'm saying is that Gannon's mandate, as I understand it, was to cure what had been found to be unconstitutional. There were findings made by the panel. Part of those findings were affirmed by this court. We have that as a roadmap as to what we were to cure, and that we carry the burden on that, and I think we have met that burden. As to those concerns that Mr. Root raises, for instance, the idea that there is a freeze, as he puts it, that although it works both ways among the different districts, that you're going to not take into account increases in enrollment, and increase in lowering of weighting, taxes, lowering of the levy. I'm saying those are matters that were not before Gannon. They were not found to be deficient constitutionally. They were not affirmed. And if we are going to now analyze those things without having a full hearing, without due process according to the state, to have a trial on those matters and try to justify that, it seems to me, at the very minimum, the court needs to allow that evaluation of the presumption of constitutionality and the deference that the legislature is normally accorded in its sort of legislative conduct. Otherwise, we result in the possibility that because of an imposition of a burden of proof, that you have something that you might find constitutional when you're looking at it for the first time, unconstitutional. And that's just an unacceptable, I think, analysis of how the Constitution should work.
But that only works if we find compliance in fiscal year 2015. Because if we find you weren't in compliance in 2015, and we can look at Senate Bill 7 and know that the same infirmities that existed in 2015 carry over, then we can look at Senate Bill 7, can't we? As part of the legislature's response to the Gannon 1 order.
I would respectfully submit you could obviously look at 16 and 17 as to those infirmities that were not cured. I mean, that I don't dispute that. But as to these new alleged unconstitutional infirmities, I think the procedure is that the panel should have decided whether to amend or not. If it allowed the amendment to include those sorts of claims, then we go forward with those sorts of processes in all litigation to present that, have it decided with all the presumptions that are accorded to the constitutionality and with all the deferences that are provided to the legislative conduct, Your Honor.
Does Senate Bill 7, from what you just said there, 15, 16, 17, is it an attempt to comply with the judgment of Gannon?
I think Senate Bill 7 goes well beyond the attempt to comply with the judgment in 7. I think that the judgment the judgment in Gannon addressed the aid components to capital outlay and to LOB. Senate Bill 7 goes well beyond that. It is a pause. It says that what we are doing is trying to analyze how to go forward. It includes in it components to say, okay, it does take the 0.4% out, and for 16 and 7, actually they raised some additional money in 15 to use. We now have an extraordinary needs funds that we can use to try to as we go forward and make these adjustments and figure out a better system, account and allow for problems. It allows a greater flexibility in being able to use the funds so that if you have funds that go into an at-risk silo of fund, the districts will have now available those funds if they need them for other matters where before they may be frozen because they could only be used for particular purposes. So Senate Bill 7 is more comprehensive certainly than looking at a cure for the problems that Gannon articulated.
It may be more comprehensive, but the starting point for Senate Bill 7 is that they got it right before so that they could then freeze it.
If the court finds that they didn't get it right before, then certainly discussion of Senate Bill 7 in 16 and 17 as it concerns those things that the court found were deficiencies in the aid is appropriate.
In LOB
we don't,
in LOB and capital outlay.
I don't attempt to dispute that if that sounds that way. Thank you, Your Honor.
Do we have any further questions? Thank you, counsel. At the outset, I read what this case was about, and I used legal shorthand to just say one of the appellants was the state of Kansas. Of course, there are two other appellants, Ron Estes and Jim Clark. I have not seen any representation today for either of those defendants/appellants. Are there any representatives here?
There are environment, I think, the agreement was they would wait on.
Very well, I just wanted to confirm that. Do they have counsel here in the event anybody wanted to ask a question from the court? I see none. Thank you both. Appreciate it. That concludes our arguments this morning. We thank all counsel for their arguments, and the court will take this matter under advisement.